So the Supreme Court issued a decision denying emergency review in a case which was seeking an immediate block on the city of New York's controversial rifle and shotgun permit requirements. So let's talk about what is now happening in this case. Now, really quick before we jump into this video, I want to ask you guys for a favor. Please just like, comment, and subscribe to this video. Liking and commenting really does help the channel to grow. It fuels Algore's rhythm. It helps to, get these videos out to more people. And then also, I just want to thank one of the sponsors of this channel, which is Firearm. Firearm is an amazing company. They've been supporting the channel for a while. And right now they're actually doing a giveaway similar to the one we've talked about before, which was the Vortex giveaway. Right now they're doing a hunting package giveaway. So if you order some products using my link down below, you will get entries into that giveaway. And if you order using that link, my personal link, you can get a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we're going to be discussing an important rifle and shotgun permit case, which was recently denied emergency intervention by the United States Supreme Court. And as a result of that denial, now this case has been thrown out by the Second Circuit. But some things have developed in this case that we have to talk about. This case challenges the city of New York's permit requirements that must be met to possess a rifle and shotgun within the city. This case we're going to be talking about is the case called Schrower versus the city of New York. This case challenges that discretionary permit system and is challenging it under the recent Bruin decision. Now, under this permit, the police department gets to determine who meets the good moral character determination. Now, the emergency application in this case recently went to the Supreme Court, but the case was denied emergency review by the Supreme Court. That meant that the Second Circuit was then free to issue their decision in this case. And as we talked about in the last video, the Second Circuit did issue their decision. They ultimately mooted the entire case, found that there was no standing by the plaintiff, and then threw the entire case out. And they vacated the decision by the lower court, which found that the good moral character standard did violate the Second Amendment and was in violation of Bruin. The hearing took place in front of the Second Circuit, and during that hearing, there were some interesting developments that happened. One of the things was that the city of New York then suddenly tried to walk out this new mootness argument, saying that this entire case was moot, that the plaintiff here, Joseph Schrower, did not have standing, and therefore the Second Circuit should just dismiss the case. New York argued that Mr. Schrower had received a permit since filing this lawsuit, and New York argued that meant that the relief he is now seeking in this case has already been obtained by him, and there is no other type of meaningful relief that could be granted by the court, and because of that, the Second Circuit should just dismiss the case. This was New York's new attempt to have the case thrown out. New York gave the Second Circuit an easy out of the whole mootness argument so that they did not have to address the merits of this case. They didn't have to actually address this case using the Bruin analysis. They gave them an easy out, and the Second Circuit took it. The city also argued that Mr. Schrower does not have standing in this case because his original lawsuit was against the prior New York state statute, but the CCIA was then passed after that and modified the old statute, and the CCIA was passed 8 days after the Bruin decision. And they argue here that originally Mr. Schrower filed his lawsuit back in 2019, challenging the old statute. After 2022 and the Bruin decision, the CCIA was put in place. So they're arguing here that the statute he is challenging is no longer valid. He has not been harmed under the new CCIA, so he doesn't have standing. They argue that Mr. Schrower may be able to still seek relief for retroactive damages against the prior 2019 statute, but under the CCIA, he has not suffered any damages. Now, when reviewing the hearing in the past, I told you that I predicted that the Second Circuit would likely try to take the easy way out, that they would find that these issues are now moot and avoid actually ruling on the constitutional merits of this case. Well, that's exactly what they did. The Second Circuit then issued a decision mooting this case. The Second Circuit stated in their order that we now hold that because Schrower has been granted the very relief he sought, the case before us is moot, and we lack jurisdiction to hear the merits. Accordingly, we vacate the district court's judgment enjoining New York City's Administrative Code, subsection 10-303A2, and declaring it facially unconstitutional, dismiss this appeal as moot, and remand the case to the district court with instructions to dismiss the Schrower's claims for injunctive and declaratory relief. They went on to state in their order that there is no indication that the city granted Schrower's rifle and shotgun permit to intentionally moot this case, or even that its action was related to this lawsuit. It is true that the city's action in granting Schrower a rifle and shotgun permit was the final action in a chain of actions that ultimately mooted this appeal. However, as explained, This action in that chain was precipitated by Schreier himself. He reapplied for a rifle and shotgun permit on October 26, 2023, after the district courts granted the summary judgment in his favor, and the city filed a notice of interlocutory appeal in this action. The city was required to timely process the new application that Schreier submitted, and there's no indication that his permit was granted for the purpose of mooting this appeal. Now, when looking at whether or not mootness should apply, there are two main considerations to overcome those mootness arguments. One being that the party tried to moot the case intentionally, and that even if the issue was moot, that the injury is likely to reoccur, that something else could happen that could cause a new injury. Schreier argued not only did the city intentionally grant his permit in 2024, after he filed this case in 2019, suddenly in 2024, they granted his permit, and that they did that intentionally to try to moot this lawsuit. And then they also argue that there is no guarantee that the city here would ultimately just take his permit even after granting it at some point. Maybe when this case is thrown out, the city can go back and revoke his permit, or he has to renew this permit and during the required year requirement, and there's no guarantee that the city would renew it. But the Second Circuit 3-judge panel did not find those persuasive. They still decided to moot this lawsuit. And based on all of that, the Second Circuit 3-judge panel mooted the lawsuit and dismissed it, and also vacated the lower court, the district court's decision, finding that the good moral character standard did violate the Second Amendment. However, like I stated, this is far from over, and now the plaintiff here, Joseph Schreier, has filed an appeal up to the en banc panel in the Second Circuit. Schreier is asking for the Second Circuit en banc panel to review this case, and if the Second Circuit denies review, that would then clear the path to go directly to the Supreme Court once again, kind of on a merits basis on the dismissal and the mootness of this case, and have the Supreme Court finally address this issue. If that happened, this appeal would also show the direct ramifications to the Supreme Court of what happened when they denied that emergency intervention, and what the Second Circuit did in response to that, playing games, trying to moot this case and have this case thrown out, so they did not have to review this issue under the Bruin analysis. Schreier argues in his petition that not only was the Second Circuit wrong in mooting the case, but also the court took the extra step to vacate the district court's decision on that whole good moral character requirement. Schreier argues in the petition to the en banc panel that the vacature of that decision, along with mooting the case for a lack of standing, is not in alignment with the Second Circuit precedent at all. Essentially, the panel there went the extra mile not only to moot the case, but then reversed the decision down below. He also argues that there is clear evidence that the city did grant the permit in an attempt to moot the lawsuit, and also that there is no guarantee at all that his permit will not be revoked or denied on renewal. So now the Second Circuit en banc panel will decide whether or not they want to take review of this case and rule on the decision which mooted the entire lawsuit and vacated and reversed the lower court's decision. I anticipate that this case will be granted review by the Second Circuit because they don't want this getting to the Supreme Court fast. They don't want it getting to them immediately, showing the ramifications of that denial of the emergency intervention. So the Second Circuit will likely take this in their hands, review it, and my anticipation that the Second Circuit en banc panel will not rule any more favorably to us, and eventually this will work its way back to the Supreme Court. So that's what's going on right now. After the Second Circuit mooted the entire case, that's what's going on in this critical, permit to purchase shotguns and rifles in the city of New York. Very interesting case showing the ramifications of what happens when this goes up and down the Supreme Court, when the Supreme Court does not get involved, and how a lot of games are going on right now in circuit courts like the Second Circuit, who are doing everything in their power to avoid actually ruling in accordance with Bruin. So if anything else changes, if we get any more information, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in the type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.